Texas justice system is messy, so let's break it down. You're listening to So You Got Arrested, the podcast that tells you what really happens after an arrest. Hosted by BRCK criminal defense attorneys, we talk to the people who've lived it, worked in it, and been shaped by it. Whether you're facing charges or just want to understand your rights, your options, and the smart moves that could change everything, we've got your back.
Welcome, this is Jacob Lindberg and James Heath on So You Got Arrested by BRCK Criminal Defense. And James, today I really want to talk about one of the most confusing, but also one of the most common, where there's tons of misconceptions, issues in San Antonio and all of Texas, and that's DWIs, right? So today we're going to talk about you got arrested for DWI, what's next? Right. So, James, what's one of the first things that come to mind? You get that new client and unfortunately they've had a DWI and you're having your first phone call with them. What's that one of those first things that everyone is just super confused about or really doesn't expect? What is one of them?
Right. So I think one of the main things that's going to affect your life right away is going to be that license suspension. Right. And there's two license suspensions, presumably, right, that we should talk about. The first being you've been arrested and you either refuse or give a specimen of either breath or blood. And then the second being when you resolve your case, if you are to take a plea or be found guilty, there will be another follow-on suspension.
So we're talking about license suspensions. You get arrested, and that's when the DPS, the Texas Department of Public Safety, is saying, look, you were arrested for this DWI. And there's at least first talking about post-arrest. We could talk about post-potential plea deals and stuff after, but post-arrest, what does that look like? I mean, in that, is there a process? What are we working with there?
Yeah, so absolutely. There is a process, okay? And the process is really going to center on whether or not you agree to provide that specimen. The specimen is almost always going to be requested as part of the basic investigation.
And by specimen, what do you mean? Saliva? Or what do we have to give up here? What do they need from me?
They're going to want to take you back to the police station and have you blow in what's called an intoxicated. Simple way to put it, it looks like a flute. Probably every adult has seen it. You got to blow into that thing. They're going to take two specimens, right? And they're going to average them together. And if that specimen is over the legal limit, then they're going to pursue charges most likely.
Okay, so yeah, you're talking about like a breath specimen and that the police are asking you, hey, we want you to blow into this breathalyzer. And you're saying if they don't do that, one of those license suspensions can go into place?
If you refuse to do so, then even if you do it, right? If your blood alcohol, if your BAC is above the legal limit 0.08, then it will be suspended for half the time. If you refuse to do it, then it will be suspended for twice as long. And, obviously they also can request blood, and depending on where you are, BRCK operates in a lot of counties. Yeah. I know in San Antonio, it's probably very common for them to do blood. In more rural jurisdictions, it can be a little bit harder, but it's still very possible. And definitely, blood is probably what law enforcement would prefer.
Yeah, and so there's a couple of ways to get your license suspended, and then the suspension itself will have a bunch of different timelines. But so we talked about kind of giving a specimen, or really all they're trying to see is what is your blood alcohol content on systems or sciences that they've made and created, one of them being the breathalyzer. I think that's probably the oldest, most common one that you hear now. And then, of course, doing a blood draw. And so if you do not consent to them pulling blood out of your body, what's going to happen then?
What they're going to do most likely is they're going to apply for a warrant. Okay. And they can even do some sort of attachment that pretty much says, they can hold you down. And force you and take your blood, in which case they'll begin the process of collecting the blood, storing the blood, sending the blood off to a laboratory to be tested, and then obviously that blood will return. And there's a lot of nuances in that whole process with room for error on their part. But that's the general typical process of what will happen if you refuse.
Yeah, so you're on the side of the road, maybe on scene, or when you get pulled over on the side of the road, you do the standard field sobriety tests, which have a ton of junk science in them. We've talked about that. But then also they try to give you the breathalyzer, sometimes on the side of the road, sometimes at the police station. Let's say you say no to that breathalyzer. Right there, that's going to spark a license suspension for at least 6 months, give or take. And then they may ask for a blood sample. They might not even ask for that first breath sample. They might jump straight to the blood sample, denying that. Right there, that's that at least 180-day license suspension, a time where you're not going to have your license and your normal driving privileges for that period of time, unless you hire BRCK criminal defense attorneys who will help you get another way into it. But, those are two things that will spark that. And again, they're trying to gather evidence to show that your blood alcohol content was above 0.08. And denying those ends up in a license suspension. So, but let's say you're willing to blow into it. In fact, you think you're below 0.08. And so you blow into the breathalyzer, and they even ask for blood on a really overzealous police officer says, you know what, I'm going to get some blood from you too. Let's say both of those come back above 0.08. Are you still facing the license suspension?
Yes, absolutely.
Okay.
And you're saying if you agreed to give it, you're still facing a license suspension. It's less serious than if you had refused.
And what makes it less serious?
Yeah, honestly, it's boring. Statutory law, right?
Yeah.
So Texas is one of the biggest DWI states in the nation. The legislature, congressmen, stuff like that, the people who write the laws have, been keyed on to the fact that people find it egregious or people are scared of it and that it should be punishment. So unfortunately, the way that it's written, even an allegation, even if you refuse and you're not intoxicated, your license will be suspended.
Right. And so there's three little caveats for the license suspension, and that is denying something, but also denying blood or breath, right? Those are the first two. But third is being guilty of DWI, not even guilty in the criminal sense, right? Like when we're in that criminal court and we're dealing with beyond a reasonable doubt, we're not dealing with that, okay? We're dealing with a much lower burden, a civil burden that's going to apply. And so what happens if you are saying, you know what, maybe the stop was bad, maybe the officer did a bad job in doing this, that, or the other thing? What are the ways, or what is the process called to contest that license suspension?
Right. So, there's an administrative hearing. Obviously, there's the executive, the legislature, and the judiciary. And some of these things kind of get pawned off and skirted into this specific branch of law called administrative law. So they can't just suspend you without giving you some sort of opportunity to be heard. But, I think you would agree, most people in this situation, regardless of intoxication or not, it's very confusing. It's very scary. You don't really know what's going on. You're sitting in a car. They play maybe an audio tape of these complex legal documents for you to listen to that kind of tell you about this. And, most people aren't going to understand. Right. So you have a time frame to contest it. You're going to go probably, by Zoom, and there's going to be an administrative law judge in Austin, right? And the police officer may or may not show up via Zoom, a computer way, and they're just going to ask the police about what's going on. And sometimes if the stop is bad, the administrative law judges will pick up on that based on the testimony and based on whatever evidence is presented in the hearing. But I think in our experience, banking on that procedure is not, I wouldn't say it's not something we recommend. It can definitely be worth it, but I think the chances are low because the burden, as you pointed out, is so low.
Yeah, the administrative law review, that's what we're talking about. It's administered by the Texas Department of Public Safety, and we're dealing with civil burdens, and it's a situation where when that officer shows up, because it used to be a lot of the times that they wouldn't show up. So a lot of these administrative law reviews were won because they're in person. Since COVID, all of them have been moved to Zoom. And so we're going to this administrative law judge over Zoom, and these officers are now more required to show up because police agencies across Texas have caught on to the issues of them losing the administrative law reviews, and DPS has gotten upset with them because there's an attorney representing DPS saying, we want this person's license suspended, right? So when you have your attorney going on your behalf, doing that administrative law review hearing, that's all they're doing is maybe trying to bring up an issue of the stop, bring up an issue with whether your blood alcohol content was really above 0.08. And there is success. It is a difficult process because at the end of the day, they'll have that third caveat we talked about, or you're driving while intoxicated. And at such an early stage in the game, it's a little tough to really overcome that civil burden sometimes. But certainly we've had success with them, but it's something where it's personal choice, right? So let's say we have the person where maybe we do their administrative law review hearing, maybe we don't. Either way, their license is now suspended. Maybe they called us past the 14-day deadline. What happens after that? How can we help them continue with their driving privileges?
Right. So there's ways around it. One, the major one that I think we see most of the time, especially in the 81st, which is, the jurisdiction that I practice in, is what's called an occupational driver's license. And occupational driver's license is essentially something where you don't have free reign, like you did before to, drive to the movies or drive to the gas station to get a bag of chips or whatever. It's a very regimented thing and say, hey, I go to work, Monday through Thursday from, 10 to 6. And then, on Friday, I do my grocery shopping and you can list out and explain all these things and petition the court to give you a license for those purposes and for those times. And obviously, there's going to be restrictions on that license beyond timeframes, such as maybe like an ignition interlock device or what have you.
Yeah. And so, what we're talking about is the occupational driver's license. A lot of times people that have their license suspended, we've got kids and work and we don't want to lose our job. And in fact, we don't want our job to find out about this. And so if you can't drive, that is a deal breaker for some people. And so the opportunity to continue driving is through that occupational driver's license. And it is extremely regimented, normally some pretty strict times where a person can drive, and even days. They don't like weekends. Why? Because people drink on the weekends. And so what happens is the court says, great, you can drive to and fro work. Maybe you pick up kids for soccer on Thursdays at 6 p.m. We can extend that one a little bit. It kind of has to be specific to your schedule. And some judges require logs saying, hey, okay, I drove this many miles this day, this many miles this day. And if you get pulled over, you're not going to have maybe your physical plastic driver's license you would normally have. You'd have that occupational license. And so if that officer's flipping through your occupational driver's license, says you have a curfew of 6 p.m. to stop driving, you're getting pulled over at 10 p.m., well, that's an offense and that's an issue. And so each court, you talked about the 81st district, it looks a little bit different. Some courts will require a hearing to get your occupational license. Some courts won't. Some courts will just sign off on it when it's agreed to. And so you're right in that it's always just going to look different, case by case, court by court, person by person. And you talked about the ignition interlock. So after you're arrested, you're not found guilty yet, but you have the ignition interlock?
Absolutely. It can be imposed as, a condition of multiple things, right? It can be imposed as a condition of bond. So your bond, your agreement to be released from custody can impose a rule saying that you cannot operate any motor vehicle without this ignition interlock. And then obviously it can be imposed as a condition of the occupational license and things of that nature. Yeah.
So that means when you're arrested and you're released from the jail, right? For our folks that have never been arrested in their lives, which is super common, you get a DWI and it sucks. And so now you get out of the jail and you're handed all these pieces of paper, right? One of those papers is going to tell you about that administrative law review hearing. It's called the DIC 24 and 25. It's going to tell you, hey, you have this many days to request a hearing for your license, that administrative law review we talked about. Another sheet is going to say your bond conditions. And that bond condition that often goes into place county by county. Some counties don't require it. Most counties will. You get arrested for DWI. You're not found guilty. You're just arrested. You're getting that ignition interlock in your vehicle, meaning you've got to blow into that thing to start your vehicle every single time. And it's every vehicle. Okay. So if that car that you're driving is your daily driver, maybe you have another car in the garage or whatever it might be, you're not allowed to drive that if it doesn't have that ignition interlock. And James and I are going to be here. We're going to come right back after the break to continue discussing DWIs.
The attorneys at BRCK Criminal Defense have helped over 5,000 clients move on with their lives. When an arrest or accusation turns your life upside down, we have the knowledge, experience, and integrity to get your life back on track. Traditional legal ethics, modern legal tactics, the best defense possible to get you through the criminal justice system. Search BRCK Criminal Defense to see our reviews and find out why so many of our clients have trusted us to fight for them. BRCK Criminal Defense, helping our clients move on with their lives.
So, James, we had finished off talking about the ignition interlock after being arrested and the difficulties and intricacies that come with that. Is there other bond conditions that a person has to worry about when they get released?
As far as it pertains to DWI or just in general?
Yeah, maybe general ones that a person will face when looking at a DWI. What are the things that they know they have to do or follow to make sure they don't end up back in jail?
Right. So it'll typically be a big list. Most of them are, at least where I practice, very standard. They're going to require you to have some sort of identification. They're going to require, in some circumstances, which is a real big problem for people, right? If you're down in Floresville or Jourdanton, but you live in San Antonio, right, you could get a magistrate who says you must reside within Atascosa County, Texas. And then you have an instant problem right off the get-go. And you're not going to be able to drive without an ignition interlock and these other things that are going on.
Yeah, so in those counties, I mean, sometimes you have a person that's released from the jail, but they're not going home or they can't go home until that condition's changed. Right. And so other bond conditions I think to expect is just not drinking or obviously no drugs at all. And those bond conditions that you're given out of the jail, if they're violated, those are promises to the court. They make you sign off on them that you're going to follow. So you don't get that interlock, you drink and you blow in positive into that interlock, or you do drugs or something like that and it comes up positive, you could see yourself right back in the jail. And so, you know, we talked about the interlock. What happens when a person doesn't drive now? Maybe their car got totaled from an accident during the DWI, or they just don't have a car anymore because they can't afford it, something like that. What will the court say to that person? Is it just saying, okay, you don't have interlock, you don't have a car, sorry, see ya?
Well, typically what I see most is they make you sign an affidavit pretty much swearing that you're not going to drive. They're not going to enforce you having to have an ignition interlock if you don't have a vehicle. However, you know, some people say, I don't have a vehicle, but then, you know, they go to their brothers and you know, your brother's like, hey, run to the gas station for me. You jump in his car, you drive his car, you get pulled over because his registration's expired. Yep. And there you are, operating a motor vehicle without an ignition interlock, and you're right back into the jail. Definitely.
Yeah. And I mean, there's going to be issues when you sign an affidavit saying, hey, I'm no longer driving. I'm not going to drive any vehicle. And then you get caught driving, right? And then oftentimes what our courts will do is they'll say, look, if you're not driving, we still want to supervise to make sure you're not drinking alcohol. And so they'll give you what's called the portable alcohol monitoring device. And so it's one of those things where it'll beep in the middle of the day. It may be 4 or 3 scheduled times that you have to blow into that device to make sure that you're not drinking in lieu of not driving and having the interlock. And so that's just another one of those things you violate, you could right back in the jail. And so having the interlock or having that portable alcohol monitoring device, you're waiting for, let's say, blood results. Let's say the officer in this case, he got that warrant, he drew your blood, maybe against your will potentially, and now they've sent it off to the lab in DPS. How long will it take for that blood result to come back to the county attorney's office?
I think typically it takes, you know, between 2 to 6 months.
Yeah.
It can take longer.
Definitely.
It can also, there's a lot of things that could go on. Obviously, you know, this is a big weight on people's shoulders and they kind of want to know what's happening. It's hanging over their head. But I mean, there's some times where maybe the results have come back, but the prosecutor hasn't even reached the file yet.
Definitely.
And you really don't have much of an avenue to, you know, get that information, especially if the case hasn't been filed or reviewed.
Yeah, and the way I always frame it is there's a box of files. There literally is. There is a box of files with people's names, and it goes by age of the case. And so if you're a newer case, you're going to go right in the back of the box. They're going to get to your case finally. Let's say it's been 2 months just for them to see your case. They pull it out of the box. They say, oh, looks like we're waiting another 4 months for that blood from Texas Department of Public Safety to be tested. Well, all right. Goes right back to the back of the box. And it'll kind of come up every once in a while. But let's say that blood result does come back. Again, anywhere from 2 to 6 months where you're blowing into the interlock device. You're struggling with keeping your license, whether it's suspended or not, right? You're dealing with all of these things. And like you said, it's hanging over your head. You don't know what's going on with the case, but the county attorney's office is still waiting for that blood result. Why won't they file it without that blood result?
Well, it's very hard to prove, right? That's why they're so fond of, the intoxicator, breathing into something that reads out a result of alcohol content or preferably blood, because they will say, in a trial, that this is a reliable scientific method, that there are scientists and experts and all kinds of studies that will testify as to the validity or, the concreteness of these methods, and juries can believe that.
Yeah, juries can believe it or choose not to, depending on how hard we argue, right? But, absolutely, right? So the prosecutor's not going to sit there and say, well, I know I'm waiting for that blood result, but I'm just going to go ahead and file it anyways. Because then now they're on the chopping block. Now, a great defense attorney like you walks into the courtroom and says, great, we'll try it tomorrow. And then they're scrambling to get it done. They're not going to file the case, meaning pursue it, start going to court, all of those things. You're likely waiting those 2 to 6 months, potentially more, for that case to actually get into the courtroom. And that's a really difficult thing for anyone. And it's a tough thing for people to swallow. Again, one of those things that people don't know that comes with these very common DWIs. So let's say you are in court, you go through the court process with us. Let's say we've drawn them up a great plea deal because for some reason we couldn't find a good reason to dismiss it. And we've got this fantastic plea deal. All right. So that time they spent, maybe 6 months to a year waiting for that case to be resolved, right? They had the interlock the entire time. They were blowing into it. They did a great job. They did community service. They did the classes for the DWIs. They were a stellar pretrial supervision person accused of a crime. Now they're accepting a plea deal that you've gotten them because it was great. Does that time they use the interlock count towards the time they might be required to have it during probation?
No, it does not.
Why not, James?
Unfortunately, that is the law. Again, that's the way that it's written up, by the legislature. Texas is really trying to combat the, drunk driving. A lot of people die, a lot of people get hurt, and they really want to discourage this type of conduct. And for that reason, there's a punishment on the front end, even before you've been found guilty or accepted guilt. And then, of course, afterwards, there's a second punishment.
Yeah. And so will the person be required to have interlock after accepting a plea deal?
It's going to depend on the facts of the case. I think with what I see most of the time, yes. But, it's not necessarily required depending on the severity of the offense, the DWI. But, I think a good rule of thumb is expect it. Yeah, expect it because, again, like you said, there are courts and procedures in which we can stop a person from having interlock on probation. But the law requires it be at least half the term of that probation. And even further, let's say we drew up a great plea deal with you because you really didn't want that interlock and you didn't have the interlock. Well, now your waiting period to seal your record, to seal that DWI afterwards is going to extend to 5 years. So it's going to stop your ability to actually hide that from your record when you don't have the interlock. And so there's all these pros and cons and nuances to these pleas that we do that we have to kind of keep track of as the attorneys to make sure that people know what they're signing up for and what they're looking at in their future. What other things are specific to a DWI plea after a person accepts a plea deal? Right. So there's going to be a couple classes, and you noted on it, you commented on it prior, right? This is going to be, a victim impact panel course, which is typically done online, which is going to have to be completed. And then there's also going to be a DWI course, which is stringent.
Yeah.
There's a DWI first, it's your first offense with drinking and driving, right? And it's not as stringent. And then there's the repeater course for anyone who's had more than one.
Okay.
Right. And there's kind of a caveat on that on the back end, right? So if you've taken a plea or if you've been found guilty, that suspension is going to be imposed, but it won't be in effect if you've done these classes within a time frame.
So you're saying after you accept a plea deal, we kind of touched on at the beginning, there's another license suspension that comes into place. And how do you avoid getting it?
Well, you're gonna get it, but the question is whether or not it's going to be in effect.
Okay.
And that's going to be, again, statutory, in which there are required classes that the legislature has imposed, and if you don't do those, your license is going to be suspended for that time frame and will be suspended until you do the classes. So it's better, right? Even if you have a great case, even if, we're going to go all the way on this, to be proactive on the front end, to be that good pretrial client, or to be that person who gets these things done in anticipation. It's also something that looks extremely attractive to a prosecutor, in my opinion, right? Because we're showing up and saying, like, hey, look, like, this case isn't very good. We have all these things that we can argue, but this person's never been in trouble before, and they've done these classes and they're doing these things and there's no more trouble, right? So it changes the tone from the get-go, and it is beneficial on the back end.
You're saying doing those classes that are going to be required on a probation anyways, it's putting our best foot forward and showing the state that we're proactive, wanting to take care of this, not going to have to be an issue for them in the future and that kind of thing. And so another one I wanted to talk about was the DWI superfine. It sounds super scary because it is, right? It's very strong. What is it and how do you get it?
Right. So it's hard to explain, and I'll try my best.
Yeah, no, just in general terms.
Right. So, depending on what it is, a class B misdemeanor, DWI first, not super high blood alcohol content, right? You could be looking at a $2,000 fine. Class A misdemeanor, you could be looking at a $4,000 fine, right? If somehow you find yourself on a third or more, right, you could be looking at a $10,000 fine. That's imposed by the court as, a plea or a finding of guilt. The superfine is an additional fine that comes, from Austin, right? And depending on the severity of the facts of that DWI can be imposed. And, they can hit you with up to an additional $6,000 fine.
Yeah, and it's going to happen on final conviction. I mean, if a client is on the program deferred adjudication, for example, even just regular probation where it is a conviction, are they going to have to pay that super fine or no?
No. So I think the best way to think about it is a final conviction, which is, again, complex.
Complicated, yeah, definitely.
Because, it comes from, cases where, you can be enhanced for prior convictions. And a final conviction under that case law and as interpreted by the courts through the government code is essentially you're resolving your case through doing time. Right. So if I get sentenced to 6 months in jail for my DWI and I do that 6 months in jail, that conviction is a final conviction.
Right. And we have clients or people that come in and they say, look, I don't want to do a probation. I don't want to have to deal with going and reporting to this person for 2 years. I'll sit in the jail for 30 days. Well, here's the legislature saying, well, that's great. Here's a huge fine for you. And it goes straight to Texas Department of Public Safety. But it's only in those specific circumstances. And so, we've talked about some of the important things to expect pre-trial and after a potential plea deal. One of these ones I always hear just clients asking me about it, whatever it is enhancements. Okay. So what is an enhancement and how does it work when you plead to a DWI?
Right. So, there's different tiers of probation, as lawyers would commonly say it. So I'll try to use that terminology, right? Straight probation, meaning that you take the conviction, that conviction is going to be on your record. And as a punishment, you're given a probationary period.
Sure.
Whatever it may be, right? There's deferred adjudication probation, which means, there's enough evidence to find you guilty, but the judge doesn't find you guilty. Instead, what they would do is put you on a period of probation, and if you're successful, they'll dismiss the case against you. Now, deferred, typically most people are fans of deferred. It's a great opportunity, a great option, right? But with DWI, right, taking a deferred adjudication can be used for enhancement purposes. And the way that it works in Texas is it's kind of what I typically say a 3-strike rule, right? And it's not to say that strike 1 isn't serious and strike 2 isn't serious, but strike 3 is a hell of a lot more serious than strike 1 or 2. Right?
And how's that?
Right. Well, because it becomes a felony.
Okay.
Right? And well, I'll be, straight up where I'm at. If you're on a DWI third, judges are not going to be happy. Prosecutors are not going to be happy. They think it's a serious problem. And a lot of times, just from the get-go, probation is going to be off the table. They're going to be looking to send you to prison. And if anything more than third, and I'm sure you've seen them, I know I have. I mean, some people, unfortunately, they have 7, 8, 9 of these. And once you get past 3, you're looking at 10 years every time.
Yeah, and so you look at that DWI first, it's Class B misdemeanor, looking up to at least 6 months in jail, potentially. And then a Class A misdemeanor is your second one, right, where you're looking up to a year in jail. Once you get to that third one, that third strike, you're looking at 2 to 10 years in prison. Probation is on the table unless you keep kind of having these offenses. And so this has been a long discussion about all of the important things that a person needs to know when they're arrested for DWI. And so we want to continue talking about these things. We're going to in the future. So please join us for the next episodes of So You Got Arrested. My name is Jacob Lindberg. This is James Heath, and thank you for joining us today.
Thanks for listening to So You Got Arrested. If you found this podcast helpful, share it with someone who needs to hear it. For more legal insights and real talk from the front lines of the Texas justice system, follow us and subscribe. And remember, BRCK Criminal Defense has your back. For more information, visit us at brckdefense.com.